Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss the doctrine of Functus Officio. You might have heard this term often, but many a times we see that it is used in wrong context. It is a specific term with applicability in both administrative parlance as well as judicial parlance. Let us first understand its plain meaning. Horton's Law Lexicon, 14th edition, defines it as a person who has discharged his duties or whose office or authority is at an end. Secondly, P. Ramanatha Iyer's Law Lexicon provides the meaning of functus officio as a term applied to something which once has had a life and power, but which has become of no virtue whatsoever. Thus, when an agent has completed the business which he was entrusted, his agency is functus officio. Thirdly, Black's Law Dictionary, 8th edition, defines functus officio as having performed his or her office without further authority or legal competence, because the duties and functions of the original commission have been fully accomplished. Fourthly, Trainer's Latin Maxims, 4th edition, explains functus officio as having discharged his official duty. This is said of anyone holding a certain appointment when the duties of his office have been discharged. Thus, a judge who has decided a question brought before him is functus officio and cannot review his own decision. And lastly, Corpus Juris Secundum defines functus officio as literally having discharged his duty, having fulfilled the function, discharged the office, or accomplished the purpose, and therefore of no further force or authority. Hence, we see that the plain meaning of functus officio is that when an office or a position ceases to have any functionality or when its functions are completed. Let us also understand its meaning with the help of Judicial Precedents of India. The first case that we will discuss is Lalit Narayan Mishra versus State of Himachal Pradesh and others. In this case, the petitioner was seeking the writ of mandamus in a case that had already been decided by the court. The court denied such relief and observed that functus officio is a Latin term meaning having performed his or her office. With regard to an officer or official body, it means without further authority or legal competence because the duties and functions of the original commission have been fully accomplished. Functus means having performed and officio means office. In other words, the authority which had a life and power has lost everything on account of completion of its purpose or activity or act. Notably, what the petitioner is seeking is virtually a writ of mandamus in a decided case, which is legally impermissible. The second case that we will discuss is Bhupendra Kumar Dash versus State of Odisha and others. In this case, the Odisha High Court observed that once a district tender committee approves a tender, it becomes functus officio. And in the same manner, when an arbitrator pronounces its award, it becomes functus officio. The third case that we will discuss is Srimati Tara Devi versus State of UP through Secretary Panchayati Raj Lucknow and others. In this case, the Allahabad High Court observed that a returning officer who had formally declared the results of an election becomes functus officio and has no further power left to rectify the errors in the electoral process. It was further observed that if the doctrine of functus officio is applied to an officer, it would mean that it has no official authority left to discharge any function whatsoever. The fourth case that we are going to discuss is BM Jain and Sons Company Private Limited versus Bombay Cable Car Company Private Limited. In this case, the Bombay High Court observed that if a court disposes of a petition with a certain direction, then till such direction is complied with or becomes complete, the court continues to have jurisdiction and cannot be considered to have become functus officio. So this is a case where it is explained when a court does not become functus officio. The fifth case that we are going to discuss is V.G. Naidu versus Pahlaj Raj Gangaram. This was a case before the Madras High Court in relation to Order 21 of the Code of Civil Procedure 1908 relating to execution proceedings, and the court observed that till the time of limitation subsists, there could be any number of execution applications, and if the statute provides power to correct certain kinds of errors, then the doctrine of Functus Officio would be subject to such qualifications, and its applicability would depend upon the nature and extent of power conferred on the authority functioning. It was further observed that the principle of finality is attached to the doctrine of Functus Officio, but there are exceptions to the principle of finality. However, the court's inherent power to set aside a judgment will only be invoked in exceptional circumstances to avoid a miscarriage of justice. Fraud is a genuine, albeit limited exception to the important principle of finality of litigation. So in this case also it was discussed that there are certain situations where the doctrine of Functus Officio will not be applicable. The sixth case that we are going to discuss is SBI versus SN Goyal. Order 21 of the Code of Civil Procedure 1908 was discussed by the Supreme Court that deals with judgments and decrees. It was observed that Order 20, Rule 1, Sub Rule 3 provides that a judgment may be dictated in open court and its transcript forms a part of the record of the case after making such corrections as may be necessary. And Order 20, Rule 3 provides that once a judgment has been pronounced and signed, it shall afterwards be altered or added to only according to the legal provisions. Hence, mere dictation does not amount to pronouncement, and therefore a judge becomes functus officio when he pronounces, signs and dates the judgment. Obviously, this is subject to the power of review and other statutory provisions. It was further observed that the situation might be slightly different for quasi-judicial authorities, and when an order is made in an office noting in a file but is not pronounced, published or communicated, nothing prevents the authority from correcting it or altering it for valid reasons. But once the order is pronounced or published or notified or communicated, the authority will become functus officio. The second last case that we are going to discuss is Komal Chand versus State of Madhya Pradesh. In this case, the Honorable High Court of Madhya Pradesh observed that the court had no power to recall and impound a certificate of sale after executing it and delivering it to the purchaser, or to reopen a case and impound documents proved after signing the decree, or to impound an instrument admitted in evidence after delivery of judgment. The court further observed that in the same manner, when a sub-registrar registers a document, it becomes functus officio, and thereafter it has no power to impound the instrument. The last case in this line is Government of UP versus Raza Muhammad Amir Ahmad Khan. It is a 1962 judgment. In this case, the Supreme Court observed that once a collector determines the stamp duty to be paid on an instrument, it becomes functus officio, and it could not impound the instrument thereafter. Let us come to my concluding remarks. After reading all these judgments and dictionary meanings, I feel that the doctrine of functus officio is a doctrine of wide application and great importance. It could be applied to both the judicial and the quasi-judicial authorities. It also acts as a matter of propriety that once an order or a decision has been pronounced, the authorities or the judges cannot take back the same. If the doctrine of functus officio is not applied, then it would mean chaos for the applicants and the litigating parties, as the authorities or the judges would be able to change their orders at whim, and there would be no certainty left with respect to any order passed by any authority or court. So with these words, I end this show. I hope you enjoyed listening to it. Thank you for listening to it. If you have any questions or comments, please make them in the comments section. Kindly like and subscribe us. See you next time. Till then, stay tuned.